Hey, everybody. What do you do when a subject in an HR investigation says, I want to have my attorney present? In this episode of the HR Investigations podcast, I'll walk you through how to respond professionally, maintain fairness, and keep your investigation on track without letting an attorney derail the process. Tune in to learn practical steps every HR professional should know.
Welcome to the HR Investigations podcast, exploring the issues, challenges, strategies, and solutions. Sponsored by RPCHR and hosted by Natalie Ivey, an HR consultant, licensed PI, and author of the best-selling book, How to Conduct Internal Investigations, a practical guide for human resource professionals. And now, here's Natalie.
Hey, everybody. Welcome to the HR Investigations podcast. I'm your host, Natalie Ivey, and I'm happy to have you with me today. In today's episode, I'm tackling a question that I get pretty frequently from HR professionals and investigators. Well, what do you do when you have a subject, the one who's accused, who says, I want to have my attorney present for my interview? Well, it's a pretty sensitive situation, isn't it? And it can feel pretty intimidating, and it's easy for you to overreact or stress out and, even handle it incorrectly. Well, with the right approach, you can really protect your organization while also keeping things fair and professional in your case. In this episode, I'm going to break down exactly what to do step by step. All right, first, let's clarify the legal context. Look, in most workplace organizations, employees do not have a legal right to have an attorney present, okay? Unlike, police interrogation, our internal, HR investigations, these are just internal fact-finding sort of exercises. These are not legal proceedings. Therefore, due process doesn't apply, okay? That said, some employees may ask for an attorney, and they may do so for several reasons. The first one is they're certainly worried about incriminating themselves. They want some guidance on what they can say, and they also may just be very, very distrustful of the process. And particularly if an employee may have had previous experience, maybe at another organization where they really felt as though they were treated very, very unfairly. All right, so they're feeling like they need some kind of representative if they're encountering what they fear is something very similar in your process with what they experienced in the past. Regardless of the reason, it's important that you respond very calmly and very professionally. Well, what do you do? How do you respond? Well, when the subject requests an attorney, I recommend that you use this kind of framework. Use a little bit of empathy and say, look, I understand. I recognize that you'd like to have an attorney present. However, our organization's policy, it allows you to have a support person present for the interview, such as a colleague or an HR representative, but attorneys are not permitted. Okay, now let's say that is your organization's policy. Now, there are some organizations that are simply not going to allow you to bring somebody else into the room, okay? What I am going to tell you, however, is that you have to be mindful of the ADA, though. Sometimes you are going to be dealing with individuals that may have certain types of anxiety disorders, or, they may have post-traumatic stress disorder. We had a case not long ago with a gentleman. He wasn't even the subject. He just happened to be a witness in a theft case on a construction job site, and he requested to have his spouse, who provides emotional support, come in and serve as a witness in the interview, and we allowed it. All right. But we had some ground rules established that it was a confidential company matter and that she was not to interfere in any way, but she was simply there to help him to keep from kind of having a panic attack. All right. So do keep that in mind. That's a little bit of a wild card now with the ADA. The other thing you might want to consider, if let's say your organization has a policy that you are not going to allow a witness to come in, obviously not an attorney, but let's say another employee just to serve as a witness. Okay, maybe a support person from HR. All right, that might be an option. Or you might want to allow having a peer as a witness. You also may want the option to reschedule. Maybe they want to consult with their attorney outside if you want to allow that. But I really do think that you should, all of you who are listening, have a conversation with your boss and your legal counsel on getting clear within your organization so you are consistent with your team on how you are going to handle it if that issue does come up, okay? And then also you want to document the request. Absolutely make a note in your case file that the subject asked for an attorney and you did explain the policy, and the documentation is going to protect you if that comes up later, your decision to not allow it if that is later questioned. Now, some investigators really worry that, I don't think I can tell him that he can't have an attorney because you think it might cause legal problems. Well, no, in reality, remember, Internal investigations, typically your HR cases like EEO, investigating Title VII, like racial discrimination or ADA, disability discrimination, or sexual harassment cases. Look, those are internal fact-finding exercises, and they are conducted as risk mitigation measures for organizations. These are not formal legal proceedings, right? And if you are allowing attorneys to attend, that can really derail your investigation, and it can turn things into these various kind of almost adversarial kind of exchanges. And they can also really intimidate other witnesses, especially if maybe the subject is blabbering to everyone in the break room, "Oh yeah, man, I brought my attorney in." And you can just imagine that now that heightens the tension around the case, and you may have witnesses that just simply refuse to cooperate because now they're really frightened. All right, now courts generally do not require attorney presence for internal workplace interviews. But I am going to say there can be certain circumstances where you as an organization might want to allow that, all right? And it really is going to also depend on whether or not you have a unionized workforce or not, because there are going to be certain circumstances when you have a labor union where that may actually be the case. Some union stewards may actually also be attorneys. And so that can be a little bit tricky because they are the union steward who is elected as a representative for a union member who's part of that labor union, but simultaneously they may also be counsel. Do keep in mind that when you have a labor force that is unionized, you are going to have to abide by what are called Weingarten rights, where they are going to be entitled to that representation if the context of the interview could potentially lead to disciplinary action. And usually this is going to be involving the subject who is accused of some kind of misconduct. But do keep in mind that generally speaking, attorneys are not going to be present in internal interviews, but there are going to be sometimes those one-offs. That's why I said, while I'm giving you these as general guidelines, these are not just absolutes. You really need to get some guidance internally with your organization, and particularly those of you who may have unions and maybe even several collective bargaining units within your organization. You need to understand that. All right, so what are some best practices during the interview? Okay, even if the subject is really kind of intense and they bring up the attorney thing again, okay, stay calm, stay neutral, stay professional. You want to focus on asking questions, and what you're looking for is gathering facts, right? You're looking at observable behavior. Remind them they can have a support person present if you've agreed to that. The goal is to just gather information fairly, all right? Remember, you're not there to provide any sort of legal advice or get drawn into a debate about their rights or legal representation. Sometimes they're going to try to wrap you into that like a ball of yarn. You've got to be very careful and have some healthy boundaries. All right, then after the interview, you want to note the request, your response, and the subject's reaction. Make sure your interview stayed focused on facts, observations, and policy violations. You're also going to maintain confidentiality, and you want to maintain consistency across all of the interviews that you're doing. And remember, employees generally, as a condition of employment, right, are required to participate in and provide information in internal investigations. A lot of businesses today have policies that are called cooperation and internal investigations policies. In my book, How to Conduct Internal Investigations, a practical guide for HR professionals, I do have a sample policy in the supplemental toolkit that comes with that book. So if you're looking for one, it's in there. And remember, because investigations are an internal process and not a legal proceeding, the normal due process rights don't apply. However, what I do want to kind of round out today's episode on is explaining what are some of the rights that employees do have when they are in an investigation. Okay, the first is they have the right to ask to have a witness present. All right, but as I said earlier, it really is going to depend on whether or not you have a labor union or whether you don't. If there is a labor union, then you have to make sure that you understand backwards and forwards Weingarten rights. If the employee you are interviewing, if it is likely that there could be some disciplinary action as an outcome, then they do have the right to the representation, which is usually going to be that union steward. But if you do not have a labor union, you do not have to grant the employee a witness, except for what I said earlier, if there might be the need for an ADA accommodation, but that's an outlier here. The other right that employees have is they have the right to decline to answer your questions. And I've had this happen many, many, many times as an investigator. And I've had people say, sometimes rather nastily, I don't like your effing questions. My response is, you don't have to like my questions, but I have to ask them. And you do, as a condition of your employment, have to respond to them. Your failure to do so will be considered failing to cooperate. And please understand, here's a copy of the organization's policy. You would have given them a copy of that. Your refusal to participate in this internal process, we've already stated it is a formal investigation. Your refusal to cooperate may very well lead to disciplinary action up to and including your separation of employment, period, end. So they can decline to answer them, but there may be some serious fallout if they don't, right? And then they also have the right to refuse to sign anything. It certainly is, one of those things. Employees can sometimes be very cagey about signing stuff. They just truly don't like signing things. They feel like, I don't know, they're joining the army without knowing it, or they're buying a condo they don't want. They just get a little funny about signing stuff. However, I will tell you, when I have witnesses that will refuse to sign it and say, no, I just don't want to sign that. If I've had to prepare, let's say, a formal statement. Now, not every organization will require that an interviewee sign off on a statement. Today, many organizations, the interview is just simply summarized with what did the investigator gather from that interview. And there's nothing presented to the individual to sign. But for some organizations that really do formal statements, when an individual refuses to sign that, what they're basically doing is they're saying, I'm refusing to acknowledge that this is what I said. I often will question them and I will say, were you not completely truthful and candid? And they'll say, no, yeah, I was. Okay, then help me understand your reason for not wanting to sign. I just don't want to sign it. I usually say, I get that, but I want to understand what specifically are your concerns in not signing it. Sometimes they still will just say, I've just been told that I just shouldn't sign anything. Okay, so what I say to them is, okay, well, what if you've gone into the dealership to buy a new car and they present you the document that says that you need to sign off on this so that it becomes your car? Are you saying you wouldn't sign it? Like, well, that's different. Okay, well, really, this is no different. You are the one who literally has been with me in this last hour interview, and I've just simply summarized what it is that you said to me. So I'm just a little confused as to why you wouldn't want to acknowledge with your own signature and confirm that this is what I captured and wrote down the context of our interview. And sometimes when you present it that way, I've had people say, oh, okay, and then they will acquiesce and then they will sign it. Others are like, I'm still not signing it. All right. Then just have another management level witness acknowledge that they refused to sign it. Okay, don't let it be a roadblock for you in the investigation. You're just going to be dealing with some prickly folks from time to time who just simply don't want to sign it. One thing you can do, however, a little tip is see if they will acknowledge with their initials that maybe the statement was 6 pages and then just initial in like the top right corner. Usually you're not going to have a problem with them doing that and saying, I'm just asking you to acknowledge that this is the document that is 6 pages. All right. But one other thing, and I know we're here to really talk about the issue of the attorney coming up, and I'll circle back to that in a moment. But I also do want to point out that you need to have a game plan for how to handle that documentation issue, and especially in unionized work environments. There are a lot of them that I've dealt with over the years in labor unions that just don't want to sign stuff, and they don't even want to acknowledge with initials. But I do recommend you have another member of management who is present, again, if you are doing a formal statement. And that way it will help you later, especially if you get down the road and you have an arbitration. You've been able to initial all of the pages. So later the interviewee can't say, oh, well, that HR lady changed page number 3. That's not what I said. Well, you had a management witness that happened to be in the room at the time in front of the interviewee. The statement was printed and all of those pages were initialed by another member of management. So if they try to play the game that something got changed, it did not, right? You have that original where it was wet signed, with the initial. Now, back to the issue of the subject who wants an attorney in their interview. Look, it can often feel kind of uncomfortable, a little tricky, but by responding politely, explaining your policy, and documenting everything, you can keep your investigation on track. Look, don't let it rattle you. I really want to thank you guys for tuning in to the HR Investigations podcast, especially this episode. This is one that a lot of my listeners wrote in about, so I decided to devote an episode to you. All right, so thank you very much to Cheryl, especially, who has reached out to me twice. Thank you for that, Cheryl. I appreciate it. If you found this episode helpful, make sure you subscribe so you never miss tips on conducting fair and effective investigations. And remember, you can also find resources in my book, How to Conduct Internal Investigations, and the supplemental toolkit that comes with that. And also, by the way, I've got a workshop coming up, and we're getting pretty close to the registration deadline, and it is my last one of the year. So my How to Conduct Internal Investigations, a practical workshop for HR, is coming up November 12th and 13th from 11 to 5 Eastern Time. That will be via Zoom. If you haven't attended one of my programs before, this is worth 10 HRCI and SHRM credits. So those of you who are certified, that'll give you a nice boost toward the end of the year. And also, it's a very interactive workshop. We do some breakout sessions. We work on some case studies. And also, we work on a mock investigation. It's a mock sexual harassment case. So you get a chance on day 2 to really practice what it is that you learned throughout the first 2/3 of the class. So, and again, this is the last one of the year, and the seats are limited. Whenever I do my workshops, I always limit the number of folks in my classes. That way, we have an opportunity to really engage with one another. We get to really talk shop, have questions back and forth, and also so that colleagues get an opportunity to really talk a little bit among themselves in the breakout sessions. If you are interested in signing up, then I recommend you do it pretty quickly. Don't wait until the last minute because we do have a deadline for registration. And right now you can take advantage of the Premier Access discount, save $100 off registration, and snag a free copy of my book, How to Conduct Internal Investigation. So I recommend you get on it. All right, so I'm Natalie Ivey, and I will see you guys next time. And always remember, the best investigation is the one you don't have to do. See ya.
Thanks for joining us today on the HR Investigations Podcast. Be sure to subscribe, like, and share the show with any colleagues who will benefit from our strategies and solutions. For free bonus resources, simply visit hr-investigations.com. And remember, if you'd like some help with improving your investigative skills, or if your organization is in need of an external investigator to help with the case, please get in touch with us. Thanks for listening, and we'll see you in the next episode.